All right. Hello, everyone, and welcome. We are just getting started with the Business of Alt Protein monthly seminar. My name is Audrey Gear, and I am a startup innovation specialist here at GFI. And today I am very excited for the topic we are featuring. It's all about how to develop an IP strategy. So this will be a fantastic overview of everything you've ever wanted to know related to intellectual property. A few housekeeping items before we begin. First of all, for those of you unfamiliar, GFI is an international nonprofit organization, and we're very focused on developing the roadmap for sustainable, secure, and of course, just protein supply. So we identify the most effective solutions, we mobilize resources and talent, and we empower partners across the food system to make all proteins accessible, affordable, and delicious. This seminar will be recorded and it will be posted to our YouTube channel. We'll also be sending a copy of the recording to everyone who registered this afternoon following the presentation. If you have any questions, please ask them. This does include an audience Q&A. If you could submit your questions via the Q&A box rather than the chat, that will help us keep track of them a bit better. You're welcome to ask questions throughout the seminar, but we'll likely only be able to get to them towards the end. And finally, immediately after this seminar, we will be hosting a virtual networking session that's done through Meetaway and the Meetaway platform. So we'll drop a link in the chat right now that will take you to the registration page so you can sign up if you haven't already. And this is just a really nice way to meet other professionals in the space. You'll be matched with a few people from one-on-one conversations, and I know I've met some really impressive people from all over the world via these networking sessions. And again, that's going to start at the top of the hour right after this seminar ends. So with that housekeeping out of the way, it is my pleasure to introduce Vince Shire as our speaker today. Vince is a partner in the intellectual property practice group in Haynes Boone's Washington, D.C. office. His practice focuses on representing clients in the biotechnology, life sciences, and pharmaceutical fields, as well as many chemical disciplines. Vince holds a doctorate degree in biological chemistry and has practiced IP law for over 2 decades, preparing and prosecuting patent applications, counseling clients in strategic IP considerations, and representing clients in post-grant proceedings at the U.S. Patent and Trademark Office. He's also served as an adjunct professor of law at George Mason University, teaching introductory patent law courses, as well as a course on patent and know-how licensing. Vince, welcome. We're so lucky to have you here today.
Oh, thank you so much, Audrey. It's a pleasure to be here. And so I'm just going to jump into the talk. And really, I'm very happy to talk about this topic. I think it's a great topic, and it's one that I think is critical to most innovators, especially startups in a very competitive space. And so what we're going to talk about today is developing an IP strategy, one that's effective and one that will grow with you. But we're going to try to set some of the foundation by explaining some of what the various types of intellectual property are and how they're used. And on this slide, for those of you who don't know, this is a picture of the United States Patent and Trademark Office, which is located in Alexandria, Virginia, a very short drive from where I am at present. This slide we've already gone through is just a simple introduction to myself, so I won't take any time with it. But just briefly about the firm that I work at. Haynes Boone is an international corporate law firm with 18 offices spread out across mostly the United States, 15 offices in the US, 3 international offices. We have over 600 attorneys. One of our 4 foundational pillars is our intellectual property practice, which is important in that we have a very wide scope of representation and services available. In fact, in the intellectual property area, we cover virtually any and every type of intellectual property, from patents and trademarks, but also covering copyrights, litigation, strategic counsel and planning, and many different technology disciplines. With respect to technology, as I said, about 127 attorneys. To give you kind of a feel, we break down and cover a very broad spectrum of technical disciplines. We have about 27 attorneys practicing across the chemical and biotech fields. About 45 of our 127 professionals hold graduate degrees, with at present 12 of us holding doctorates. But that's enough about the firm and me. I'd be happy to talk to you more offline about Haynes Boone as well as myself. But what you're here to see is really a discussion of how intellectual property really fits into your growing business. And with that, today's agenda is going to cover a very large number of topics. So unfortunately, we can't take a deep dive into each and every one. I think every single topic here is worthy of its own long form presentation and perhaps hours of conversations. But what I'm going to try to accomplish today is just sort of to give you a sense of the basics of intellectual property, how we think about development of a IP portfolio, a very important question of trying to decide between trade secrets versus patents, and then focusing a little bit more on the patent end of things, about what makes an invention patentable. How do we think about it in terms of the legal thought process versus perhaps a scientific thought process. And then we're going to talk about some of the more generally applicable concepts of how our IP is used to establish sort of a competitive advantage on a global marketplace, how we budget. And then we'll finish up with a guide, sort of a quick reference guide for entrepreneurs to sort of guide you through some of the thought processes. And so why do we focus on intellectual property? Well, intellectual property is really important because it provides a number of advantages to the innovator. One is, in fact, it's rooted in our Constitution to promote the progress of science and the useful arts. In fact, that's what intellectual property does. It promotes innovation. It gives people an incentive and reward for innovation. And we do that by safeguarding the contributions that a party would make towards that innovation. And in so doing, we help a company grow, we create jobs, we can bring new goods and services to the marketplace. In fact, looking at the Department of Commerce's economic survey from 2019, we see that about a third of the US total employment comes from IP-intensive industries. It's about 62.5 million people. But it also accounts for about 41% of our US gross domestic product. So IP-intensive industries are really at the heart of our economy. And from a personal standpoint, personal incomes are over 60% higher in IP-intensive industries than non-IP-intensive industries. So there's no doubt why we focus so much on intellectual property. But what is intellectual property? It really flows from the concept of ideas. What we're talking about when we talk about intellectual property is the concept that we can protect somebody's idea. And it can come in 4 different varieties. One is copyrights, another's trademarks, patents, and then trade secrets. So first of all, let's think about copyrights. A copyright, many of us have been exposed to in one way or another. What this does is protects the rights of a creator of an original and tangible work. So these are items like songs, photographs, books. From a commercial standpoint, a way to think about this is about your promotional materials, your packaging, your product instructions, any original tangible piece of written material, or you can obtain protection for. And the concept of packaging, it's really a demonstration of the originality of the packaging itself. Trademarks. Trademarks are a very important intellectual property right. It's important because it creates a brand identity. And it does so by distinguishing the source of goods from one party, being you, from those of another, which would be your competitor. Trademarks themselves are potentially perpetual, but with certain requirements. One, the mark has to be in continual use. And second, you have to exercise some control over the qualities of those goods and services. Sometimes we see different designators for a trademark, the little R with a circle or the little TM. What that corresponds to is whether or not a mark is registered with the US Patent and Trademark Office and has certain benefits of federal protections under federal law. An unregistered trademark should be designated by a TM. That just is it has common law protections or state law protection. Now, trademarks are typically used for words, phrases, logos, symbols, designs, or some kind of combination. Perhaps some of the more readily recognizable examples are the word Apple, for example, to cover an entire company. Another one is the swoosh from Nike. It's a symbol. Whenever you see that swoosh, you immediately identify that with Nike. How about patents? So a patent is a little bit different. A patent is dealing with inventions. And what a patent does is it grants the inventor an exclusionary right. And what the rights of exclusion are is that you can prevent a third party that has not obtained a proper license from you as the inventor from making, using, selling, offering for sale, or importation of that which you are claiming. Patents, however, are sometimes you hear of it referred to as a limited monopoly, and that's not necessarily the monopoly, may be a little bit of an overbreadth in statement, but the limited, it deals with the concept of time. What we're looking at is that it is not an indefinite right. It's not a continual use right. It is limited to 20 years from the date of your first filing. Patents are also limited in terms of jurisdiction. Their geopolitical scope is limited to the office in which, or the country in which you seek protection. What that means, in essence, is there's no worldwide patent. So having a patent granted in the United States does not grant you rights in, say, Germany or Japan. You would have to seek individual protection in each of those jurisdictions. But a patent really is there's a bargain for exchange, a quid pro quo to obtain a patent. So in order to receive this right to exclude, there's a requirement to promote and satisfy the objectives of congressional intent to promote the progress in science and the useful arts, is to put into the public domain an adequate disclosure of what your invention is. And the concept is, by putting into the public domain a disclosure and to be able to carve out an exclusionary right to prevent others from being able to practice your invention, you have to provide certain details so that someone in the art can understand, looking at your description, the manner and process of making and using your invention. So we're looking at how clear and concise terms are. There's also a concept of enabling someone of skill in the art to be able to make and use your invention. And the third part of the disclosure requirement is that we're required to set forth the best mode contemplated by the inventor to carry out the invention. In other words, they don't want you to hide the secrets of what makes your invention work. You're obligated as an inventor, as part of the quid pro quo of the patent system, to provide a sufficient description to allow somebody who wants to practice it to actually do so. So the United States has 3 different types of patents, and each has their own unique unique jurisdiction. The first is dealing with design patents. Design patent, many of which you probably recognize here, is the Lego character. This is a design patent will cover the aesthetics of a device or an invention. So what we're talking about is not the actual use of, but rather so sort of the making and using of an invention. What we're talking about is what it looks like. And in this case, what's being covered is that design characteristic of what makes a Lego a Lego. The second is a plant patent. What a plant patent is a unique jurisdiction that covers new varieties of asexually propagated plants. And here's just an example. So you can see there's slight differences between the two and how they are showed up, and also the way the patent numbers are designated. The third, which is probably the most common that we would be looking at and talking about in the alt protein space, is the utility patent. A utility patent is something that covers a new and useful process, machine, manufacture, or composition of matter. And so it's a new way of doing something. So this is typically what we think of when we start talking about patent rights. Typically, we would be referring to a utility patent, although the rights extend equally to design and plant patents as well. Often what I tell people when we talk about IP portfolio development is not to overlook design patents. There's some very important cases where a utility patent may not be ultimately what saves the day, but a design patent may be useful. And design patents and trademarks kind of go hand in hand in covering more the aesthetic or the recognition of a particular symbol to represent something. How about trade secrets? Well, a trade secret, not surprisingly, is something that is a secret. But it also requires that the information confer a competitive advantage and also must be subject to reasonable efforts to maintain that level of secrecy. If we lose any of these three elements, then ultimately the trade secret protection would be lost. So let's take a little bit of a closer look at what each of these is. So a secret, well, the concept of a secret really deals with that the information that you are desiring to maintain and some protection for, it must not be generally known or readily ascertainable by competitors. So the closer it becomes to general public knowledge, the less likely you are to be able to hold certain levels of rights to protect the information. The competitive advantage deals with either an actual or a potential independent economic value, but that economic value has to be tied to its nature of not being known. And finally, the reasonable efforts to maintain secrecy. There's a lot of different components that go into this. One important one is confidentiality agreements, not just when dealing with potential business partners, but even within the company, to put strict limitations on the ability of an employee to disclose information that you intend to maintain as a trade secret. So it also deals with non-compete agreements. So we want to be able to limit the rights and the abilities of any party, whether an employee, contractor, consultant, business partner, from being able to take that information and directly compete against you. IT security is a component of whether or not we've exercised adequate measures to maintain secrecy of our information, as well as controlled access and access audits. All important components to the reasonableness of the efforts that we undertake to maintain information as a trade secret. Now, the competitive advantage, there's a lot of different factors, and they're highlighted here. Some of it has to do with the value that that information would have towards an owner as well as its competitors. The type of effort and money that went into developing that information, as well as things like the efforts, again, to maintain that information as a secret, how hard it would be for somebody else to replicate or independently come to have access to that information. So with that framework of understanding of the different IP rights, when we think about an IP portfolio, it's really the combination of these. Copyrights aren't included here because it doesn't typically fall within what we think about when we're talking about intellectual property rights, but I throw in there just the note to think about copyrights again on product materials, promotional materials, packaging. But when we look at an IP portfolio, what we're looking at is kind of this meshwork of our patents, our trade secrets, our trademarks, as well as in-licensed technology becomes all a part of the portfolio that a company holds. So when we look at how we want to develop a portfolio, there's a number of questions we have to go through and try to decide where we stand. What kind of answers do we have? So, some of them deal with the development objectives, like what do we look to be as a company? Are we developing products, or are we really there for research and development? Is that what we're trying to accomplish? What are our end goals? Do we wish to produce a product to introduce into the market, or are we trying to develop a portfolio that we wish to be able to sell as an asset? Are we looking to just build up a portfolio to have access to a licensing stream, or are we really looking at as creating value in a company to be acquired? It's important to think about where we are in a corporate development cycle. Where are we in the funding rounds? Our IP portfolio development needs and direction is often controlled by where we are in the development cycle, where we project ourselves to be, and what our next timeline would be to move from one round to the next. We also want to look at what our assets are. Are they tangible or are they intangible? Those kind of questions deal with directly addressing what kind of the products we want, what products do we have, how do they match with the different protections we might be able to get. And so all these questions are things that we would try to come together to map out a game plan, because there is no single answer. No two companies really can address the ultimate portfolio question exactly the same way. For some companies, it is that they have a strong desire for patents, versus other industries maybe, or other companies favor trade secrets. But one thing that you can always bet on is that the right answer always will have a blend of some level of trade secret, some level of patent protection, and some level of trademark. So when we think about the development of a portfolio, we could think about it in a similar way we would think about creating home security. So you take this Midwestern community, and we pick a house, and we want to think about how we would protect our home. It's the same concept that we look at when we try to protect an IP or develop a portfolio. We start from wanting to protect our house, right? Your first effort is focus at home. What does that mean? Well, we're protecting our products, our core. What is the core of the company? That's your house. You want to protect that. Next, we want to push the boundaries out. We're looking at how do we protect our yard, right? So not only is it just the core idea, it's that which is closest in proximity to it. The next thing we would do is we want to identify what is our market as a whole. And we want to be realistic about what our market is. How big is it? What are the types of players in our market? And when we start thinking about the players that we have to interact with in our market, we want to look and identify where our external threats are and assign a relative level of risk. The closer those competitors are in the marketplace to our home and our yard, the more we want to think about how we can box them out. How can we protect that space to mitigate that risk? But the further away they are, the less we need to be directly concerned with them. So we want to expand our IP to form a sort of a safe zone where we're cutting off and boxing out the biggest threats to us. Then we want to look at where our blind spots are after that. Where in the marketplace are we still not covering? And we want to ask the questions of how can we go about protecting as much of this space that's in our blind spot as we can to provide our company with the greatest likelihood of success. And there is, again, no one solution. It could be through many different ways of additional intellectual property. Some of that might be kept as a trade secret. Some of it we might identify that we need to in-license the technology of a third party. We might need to outright acquire an asset of a company to provide us with the best strategic positioning. Or it might just be through creating collaborative partnerships, joint research agreements, joint ventures, so that we can mitigate the threat that that third party would pose to us in the market as it surrounds our core IP. Now, the question of trade secret versus patents is always one that has a lot of pro and con. And again, this is why there's no right answer and there's no ultimate wrong answer. There's just the answer that we work through by taking logical approaches. So let's look at a lot of different factors, and these aren't all of them, these are the bigger ones. First is duration. Well, a trade secret is potentially unlimited, right? So long as you can preserve that secret, it potentially lives on. Whereas patents, I spoke earlier about, is you have a limited lifetime. So for utility patents, it's 20 years from the earliest filing. So in theory, from a duration standpoint, that would favor trade secret protection. When the right becomes effective with a trade secret, it's immediate. As soon as you have the information and you take steps to protect it, it becomes effective and trade secret protection extends. With patents, it goes through an examination process. So from just using the latest USPTO statistics, it takes a little closer to 2 years from filing an application until the actual exclusionary right attaches upon patent grant. So if you think of it in terms of the delay being a detriment, again, this favors maybe it's trade secrets. Disclosure requirements. Well, these really are the crux of the difference between the two protections. A trade secret, by its definition, you're prohibited to disclose. You need to maintain tight confidentiality controls. Whereas in patents, you have to provide the disclosure. You're giving away the details. What is the best way we know to carry out the invention? Well, that's kind of a push. There's some pros and cons to each one. From an exclusivity standpoint, the benefit in a trade secret really comes from not telling anybody. But the problem is the exclusivity only applies and the protections only apply so long as it's not arrived at through proper means by a third party. So there's no way to prevent a third party from reverse engineering or coming up to independent development. You can't even cut any third party off from obtaining their own patents. Whereas a patent is an exclusionary right, and there's an absolute right protected under federal law to prevent others during the enforcement period from making, using, selling, etc. So that tends to favor patent protection. You have a stronger scope of protection. Enforcement, trade secret is got a limited scope of enforceability, and we're generally a very difficult burden to carry to prove it, and it's only covered under state law. Whereas patents has federal protections, and you are looking at any potential infringer of the scope of your claims. And that is generally easier to prove, and it has a more well-established procedure that we go through to evaluate infringement. That tends to favor patents. On the licensing and sales end, because everything has been secret and there's certain measures you need to take to limit access and control, trade secret licensing and sale is often complicated and difficult. Whereas a patent is a patent right. We know what the scope of rights are. We know what the asset is that's being sold or licensed. And so it typically favors patents. Cost, it's kind of, again, a push. Whereas there's no registration cost for a trade secret, the measures you have to take to establish and maintain secrecy can become very expensive. Patents, they're expensive to obtain. We're talking generally $25,000, $50,000 over the course of a 3 to 4 year period. And then we also have foreign jurisdictional costs if we try to pursue patent protection there. So that's costly as well. It's difficult to quantify really which one is better or worse. So that's kind of the metric we would kind of walk through. But to decide which way to go, we have different considerations, and it's unique to every company. Some are internal considerations, others are technology considerations. So if we look at the internal considerations, what we're talking about is, what is your economic situation? How do we as a company look at our economics, our finances, what we expect to be revenue streams? That will help us decide what we maintain as a trade secret, what we might file and seek patent protection on. Other questions deal with the ability of us as the trade secret holder to maintain that and police that secret, right? So one of the important things is always be using strict and robust confidentiality agreements, being very careful about putting term limits on your period of confidentiality, because that will sunset your term of trade secret protection. In fact, I've seen this in many shared research agreements or general NDAs that you might get through a lot of different settings, companies, universities, other types of arrangements, where through inarticulate drafting, the lack of careful planning, parties will have confidentiality language, the requirement to maintain information in confidence. But then when they have the termination clause, it doesn't close off the and isolate information that may be shared under the NDA that constitutes a trade secret. And the result is that the termination clause, which puts a term limit on preservation of confidentiality, in effect creates a trap that allows information that was otherwise designated confidential to lose its confidentiality status after a year, 2 years post agreement. And ultimately what that does is it puts an end to your trade secret protection. Now it potentially becomes freely available and you voluntarily waive that right. And so confidentiality agreements always require careful review. You need to know how close you can restrict within an audience of business partners or within your company. How can you go ahead and effectively restrict the knowledge? Also, you need to have a real careful evaluation of what your commercial lifespan might be and what the competitive benefits you're seeking for determining whether you want to pursue a trade secret versus a patent. Technological considerations, we look at things like patentability. How likely is a specific thing to either pass the patent eligibility test or the novelty and non-obviousness test? We look at how likely it is for the technology that you would otherwise think of patenting or hold as a trade secret. How likely is that to be reverse engineered? Products are generally easier to reverse engineer, processes much harder. We would also look at some of the other sort of intangible factors about detecting infringement. What other competitors are in the marketplace and what are they seeking as potential solutions that are similar? Trade secrets, most commonly used and probably the most critical place that they're used, deals with data. These are a critical competitive asset. What we're typically looking at when we talk about data that we would keep as a trade secret are customer lists, internal operating procedures, survey results. These are not patent eligible, but they're critical to the functioning and the future planning of a company. Processes, as I said, these are typically harder to reverse engineer. Some of the examples you might look at are some manufacturing methods or how you go about testing a procedure in clinical practice or within your laboratory. The caveat with processes is that if you ultimately seek a patent on your product, you may end up having to disclose those manufacturing methods, for example, and that disclosure ends up taking away your trade secret protection. So you always want to think about any downstream patent applications that you're filing. How does that have an interplay with your sought trade secret protection? When you have a product that's really hard to reverse engineer, in other words, has a lifespan that's long, and it has a lifespan that's longer than what a patent would grant you, then that favors trade secrets. And some of the classic examples that we think about to illustrate this point is WD-40. In fact, nobody still knows what that is, but that was invented back in 1953. Had they pursued at the time patent protection, it would have been, that patent would have expired in the 70s. But yet here it's still commercially available and a very valuable product. Coca-Cola, the original formulation was first sold in 1886. And it's been one of the longest held trade secrets. And Coca-Cola is commended on so many levels for the efforts that they put in place to protect that particular formulation. But maybe the most common use of trade secrets that we think about is we're just not ready to patent yet. This is a form of trade secret protection. Many of those technologies will proceed to patenting, but during the time frame before we make that disclosure, it is in fact held as a trade secret. It's something that we're exercising control over and we're not disclosing, and we're very careful about how we disseminate that information. Because if we fail to do so, we end up potentially losing the very patent rights that we're seeking to protect. Just a word of caution is the longer we go holding something as a trade secret, it may ultimately have some deleterious effects on our abilities to secure a patent later. How about patents? Where are some of the common situations? In the most recognizable one is that we're trying to protect a commercial product or process. But in this particular audience, where we see it frequently come up is when we're talking about trying to obtain funding. We're trying, by having intellectual property assets, it puts some tangible limits on what we are doing, how we're protecting it, so that there is a better way to evaluate a potential return on investment. And so it has a very important interplay with funding. It also ends up we end up looking at these as a vehicle to drive joint ventures, also to secure perhaps royalty streams, cross-licensing agreements. But the biggest point is we want to increase the company value. More patents, more high-quality patents typically provide actual financial value to a client, to a particular company, and makes you either have a bigger footprint within your market that you can exploit, or you become a more attractive acquisition target to a perhaps bigger entity that's looking at your ideas and saying, that's the solution we need. So when we look at a patent, you've heard me talk about the claimed invention a couple of times, and to quote Giles Rich, former Chief Judge of the Federal Circuit, the name of the game is the claim. When we talk about patents, it doesn't matter what's described in the application. When we talk about the exclusionary right, it's the claims themselves. So going back to my property analogy, think of it similar to a deed to that property. A claim is what defines the legal boundaries of your invention. It tells people what it is that you are claiming, what is the breadth that people cannot practice. So when we think about claims, it's important to draft claims that provide us with value. They protect our products. They protect our area of the market. But also just as important is we need to be able to defend the validity of those claims, and also be able to have claims that have some actual purpose and application, so we can actually detect infringement. It doesn't do us much good to have a claim that looks great on paper, but we have no way to determine whether or not a third party is actually stealing our invention or not. So looking at patents in terms of the actual process, there's some critical requirements. The first one is we need to meet patent eligibility criteria. The easiest way to look at it is a process, machine, manufacture, composition of matter, and that's an article of manufacture. But this has actually become a very controversial area in the United States over the last 15 years, when we start looking at the interplay and how abstract ideas, laws of nature, and natural phenomena interplay with the eligibility of a patent. And so it always needs careful evaluation by a professional to be able to determine what our risks are, and whether or not an invention involves one of these, what we think of as judicial exceptions. Your claims must be novel. So what you're claiming has to be new, wasn't previously described or in the prior art. It must also be not obvious. And so this one becomes a little bit of an interesting item that we'll talk about in a moment. But what we're looking at is the differences between our invention and what's in the prior art, and asking the question whether someone with this hypothetical ordinary skill in the art would have found what you're doing and trying to claim to be obvious. And also we go back to that description requirement that we talked about as the quid pro quo of the patent system. It's providing sufficient detail so that it's clear that you were in possession of the invention, and that a third party could pick up your application and would be enabled without undue experimentation to actually practice what you're claiming. And whether or not we've provided the best way or the best mode known to the inventor to practice our invention. So novelty, really quickly, what we're talking about is an all elements rule. We're looking at the claims and asking, are all the elements that we are claiming either expressly or inherently present in a single piece of art or a single act that was in the public domain? There is a limited grace period given to inventors in the United States that other countries don't provide, that has to do with if you've put into the public domain through patents or a printed publication, or you've used it or offered even for sale prior to the date you file. In the US, we get a 1-year grace period from those actions. It's a limited grace period because it could be cut off by third-party action in the interim. Most other countries have absolute bars to novelty. So if you perform any of these acts before you file, you could actually create priority against yourself. And there's also a limited grace period that deals with when another party has filed for an application before you, and it has to do with the relationship between you and the other filing entity. If it was done by yourself or a joint inventor, you might have a grace period you could protect yourself under. If it's commonly owned, there might be a grace period. But if it's by another party, they would have beaten you to the patent office, and we fall under the current rules of first inventor to file in the United States. Now, the obviousness is an important one because it's really the transition from what I always thought of as lab think to legal think. And this is a critical transition for inventors and practitioners alike. When inventors when we look at inventors, typically they're people that we would think of as having super skill. They may have PhDs, they're intimately involved in the research in this particular area, so their skill level is super high. But thankfully, what's obvious to them is not what we consider the legal standard. What we're looking at in patent law is the person of ordinary skill. And so that's a hypothetical person who's presumed to know the relevant art at the time of the invention. And then we look at, to establish what their skill level would be, is certain factors, like the types of problems that existed in the art, what other people in the art have tried to do, how quick the evolution of that technology is, how sophisticated is it? And then we look at the general education level of people who are physically working in that field. All those factors feed to the determination of who that hypothetical person would be And when we're asking what would be obvious to that person, not the inventor or somebody at the inventor's level, not an expert. But of course, that person of ordinary skill is also assumed to possess a certain level of creativity. So we think about what inferences and creative steps that that person would naturally employ on the basis of what their skill level is. So why does that really matter? Right? That's always a question. Well, it matters because most inventors come to a mistaken belief that their invention is obvious or just flows from the prior art. And that type of thinking prevents, especially startup companies who are really intimately focused, sometimes for years, on their technology and developing their idea and their product. And they've read up on lots of different things in their particular space. They've gone to conferences, they've talked to people, they've acquired a super skill. And then what they end up doing by looking at it and saying, oh, no, it's obvious. So anyone would have done this. They ultimately prevent themselves from getting the protection of their ideas when they matter most. And that's really at the beginning of the company's formation. Just remember, to you, it might be obvious, but that does not mean that we still can't protect it or that it is worthy of patent protection. Even if the big picture idea is obvious, when we write applications, we always, you could think of it as an onion where you peel back multiple layers and we build out from a core. You could think of it as, protecting your front porch and building out your yard. You could think of it a lot of different ways. But when we write applications, we always want to focus on variations, different embodiments. Even if the product is obvious, maybe you have a new way of making it. Maybe you have a new device to make it. So there always is aspects or narrow embodiments that we might be able to protect, even if the big idea might ultimately fall as being within the what we would think of as being obvious. So when we think about a global strategy for patent protection, going back to the concept that there is no global patent right. They're all territorial. So for startups, this is one of the most important and often difficult questions that we need to face. And that is, how do we develop a global IP strategy? Because there's lots of concerns that go into this. How many countries should we file? Think about how many countries there are in the world, and I'll give you an illustration in a moment of how many countries you could theoretically file in. But how many countries should we file in? Where of those countries should we focus? How much will it cost for each country? And how about filing management? How do I make sure that I'm getting the most out of my intellectual property in each and every country that I'm filing in? And what about results? Timing. Are these going to come out around the same time, or is it going to be staggered? Am I going to get an inconsistent result in one country versus another? These are lots of concerns that go into the development of a global IP strategy. One very common mistake that startups enter into is sort of this thinking that I need to secure my domestic market first. And I say that's a mistake because you have very limited times once you file your applications or there's competitors in your space to take action to protect your ideas and to develop your IP portfolio. And by focusing solely on a domestic market and thinking I'll get to the global issues later, if you don't do it right, you may ultimately miss the boat. So, although the US is arguably the most important market, and I think probably in almost every industry sector, it probably is from a commercial return. Most companies will file in anywhere from 2 to 6 foreign jurisdictions on any one particular foundational patent. So it's really critical that you plan this at a very early stage, because you want to make sure you don't miss your dates, but you also need to set your budget. So where a company will ultimately file is dictated by several different factors. When you think about your industry, where are these other companies filing? Looking at the industry leaders is often a good indicator of where you probably should be filing as well. Look at what you think your marketing reach and marketing partners might be. Where do you think that technology might have the most commercial return? Where are you going to produce it? Is it going to be produced here in the US? Is it going to be produced abroad? And how is it going to be shipped into the US? Where are your competitors? Are they in the US or are they foreign? And when we look at a lot of these different aspects and we look at things like what is our end goal, we want to come up with a plan that matches the countries with our specific ideal of what we want to create as sort of a protective shell around our intellectual property. Just as a point of reference, the most common countries that US companies, especially small startups, will pursue protection in is probably in this order: Europe, Japan, China, Korea, and Canada. There's a few different application types that we'll just quickly introduce, just so you can get a feel for the language. One is a provisional application. US provisional applications are really low cost. They're very loose requirements of what has to be provided. They're not examined, so they don't obtain any patent rights. But what these are very useful for is establishing early dates, to establish your filing dates for certain technologies, or where you are at a certain state, at a certain date and time. Because you want to get these provisionals on file to establish, as for this scope of technology, this is my date, I have claimed a right to it. So then I have the ability to go forward and have a little more freedom to talk to potential investors, to talk to maybe, or put a product demonstration on. So it's really good to use, especially in series as the technology evolves or the marketplace evolves, to file these in series. And so you'll have 1, 2, 3 that just build on each other. But you have 12 months from the filing date in order to take action with it, and to claim the benefit of that early date. If you don't, you would lose the right to. These provisional applications will remain in secret until they're referred to in a published application. That usually happens at about the 18th month mark from the date of filing. The second type we talked about and introduced a little bit before is a utility application. This is one of the 3 types that have the exclusionary right. And that exclusionary right comes about as a result of examination by the USPTO. For small and micro entities, there are discounted government fees that would apply to help save money and make it a little more cost effective for small companies to pursue protection. These will publish, and it's 18 months from their first priority application. That's when it goes into the public domain. But the rights do not attach in its broadest sense until the patent is granted. Just some numbers, although roughly 2 years is what you're looking at in the biotechnology and chemistry field. It's actually a little bit longer time span. Current allowance rates sit around 70%, but when we're talking biotechnology and chemical type inventions, we're closer to 60% right now under the current statistics, which is actually a good place to start from. Your odds are better than 50-50 that you're going to get a patent. The question really ends up being a question of scope. PCT application, what this is an international application that's filed. It receives a very broad international search by the International Search Authority that just generally gives a degree of relevance and applicability of prior art. So it's a way to look at, to get a quick peek at what prior art you might get to assess the odds of maybe your abilities of your claims surviving if you file applications. Examination is fairly limited. It looks at a few concepts of unity of invention, industrial applicability, novelty, inventive step, or non-obviousness. You have limited rights to make an amendment and maybe ask for a second look on your amended scope. But the evaluation of the PCT application is not binding on any member country, and in fact, it does not even provide any exclusionary rights because it's never officially granted as a patent. You have to transition those into the national stages of the various member countries, of which there's 156 member countries. The three notable exceptions are Taiwan, Argentina, and Venezuela. And just thinking back to our discussion about global IP strategy, you can see there's actually over 160 countries that grant patents. And so identifying which countries and in what order is really there's a science to it, and there's an art that varies with each and every company. The biggest reason to use a PCT application, though, is that it is an effective tool to defer costs and get a good indication of how your claims are going to be received. I already introduced it, the national phase application. That's what follows from PCT. This is when you enter into various national offices across the member countries, and the examination there is dictated by local jurisdictional laws and procedures. The UK, just as a special note on the European Patent Convention, the UK is a contracting country, so Brexit does not impact whether or not your patent can be pursued in the UK through the European Patent Office. Once a patent is granted by the European Patent Office, there is an administrative step of validation, and that's just registering in the countries you wish to have enforcement rights in. Some of them have translation requirements. So now that you know the different terminology, let's look at a common strategy. One of the most common strategies exercised by startup companies is we start with a US provisional application. So this is as our technology is developing, we put this placeholder, which establishes rights. We have a year to file, and typically people will file a PCT application next, so they can get that look at a lower cost, and it can get an identification of maybe the relevant art, how their claims will be looked at. And then we enter the national phase. We have basically that 30 months from the date of the US provisional application to get our national phase in, with the slim exception, there's a 31-month one out there. A lot of companies will simultaneously file a US utility application. So at least you get your US patent rights in process rather than deferring examination for 2.5 years. As I mentioned earlier, one of our common strategies is these serial provisional applications, using multiples as your technology develops. You can just envision the use of several of these building on each other to build that priority chain. But you still only have 12 months from that first filed application. So where I promised to finish is sort of an entrepreneur's guide. This is going to look at where we go from innovation to ultimate success. How do we fit our IP in there? And how do we take these pieces that we've already talked about and make it fit for you? So the first thing we want to do is we want to look at IP as being a real critical component to achieving success for your business. And we need to look at that at every single stage of our corporate development. Whether it's from our very early pre-seed rounds or we're all the way through and we've already gone through our fundraising. Your IP portfolio always needs to be tied into your business plan. They are co-extensive and not mutually exclusive. We need to keep these together in some way, shape, or form so that our company and our IP strategies grow together. At an early stage, it's always important to have a one-page sort of general IP strategy overview prepared. Obviously, we want to keep it general because we don't want to disclose confidential information or tip off exactly what we're doing. But it's good to show to investors and to incorporate it into a fundraising pitch that we have a plan. We recognize that intellectual property is an asset that enhances the value of our company, and that we have a game plan for how we're going to achieve that and how we're going to tie our IP strategy into our company's growth and ultimately return on that investment. But as we move through the rounds, our IP strategy will have to transition and change to be to match where we are as a company and where we are in our development cycle. Being careful, very careful, that despite the urge to tell the world about your ideas, remember, you do need to keep certain protections. If you disclose early, it could harm you in some pretty dramatic ways. So you have a new idea. Great. What do we do with it? You want to write that down. You want to keep that in a safe place. Draw your pictures, identify features you think are critical, and give you a competitive invention. What makes your idea special? And then expand your idea. Think about how you can modify it. What if you were a third party and you saw that idea? What would you do that was different to try to get around it? And so you try to build your idea out. Before you tell anybody else about it, consider whether you want to go trade secret or patent protection. Put a plan in place to control disclosure of information. Think about your provisional application, and before it expires, you want to talk about budget. You want to talk about where your company's heading, whether we want to go utility or PCT. What are we covering? What are we protecting? Well, how do we know the right path? Well, that's a tough question, and it's normal not to know. But that's where an IP attorney comes in. A registered patent attorney has not just a technical background, we've also passed the patent bar exam, we've gone to law school, and we've also passed state bar exams. So you need to hire a qualified IP attorney, somebody who is best equipped to help you navigate this process. Right, that's what we're here for, is to develop these comprehensive plans and to help you walk through the process to ensure that you get the return on that investment. But be careful, not all IP attorneys are created equal, right? So you have to do your homework and look at what is the best fit for your needs. And that might be different than a different company. Just because you get a referral doesn't make them best for you. Kick the tires, look at the IP attorney. What is their technical capabilities? What is their level of experience? Can they support you, or have a network of other attorneys they work with that can support you in the spectrum of legal issues that you will encounter, not just when it comes to IP, but maybe capital markets, venture capital, private equity, regulatory issues, etc. These are all factors that should be taken into account when talking to and trying to evaluate what fits best for you. Don't forget your budget. Don't focus on the short term. So many companies, especially startups, look at the cost in it, and it can be alarming. And they focus only on what's in front of them today, and lose sight of what their goals and their long-term costs might be. Failing to take into that long-term, well, when you think about the long-term costs, you need to include all prosecution and IP costs, as well as government fees. And whether or not you succeed in protecting your ideas and creating the right IP platform will be directly related to the investment you make in obtaining high quality patents from the very beginning. So just remember, to an extent, you get what you pay for. If you're short-sighted on budget, it will harm you and probably cost you a lot more in the long run. And there's a lot of ways that happens. Reduced chance of getting a patent, you omit specific details, prosecution takes longer, narrower scope, harder to enforce. There's a lot of different ways. But don't fall into the trap as well about putting all your eggs in one basket. One patent, it's good, but if all you have is one patent to protect your IP, your actual products in your company, it makes it that much easier for a third party not to take you seriously and to infringe your patent rights or try to invalidate your patent rights, and you could lose everything. So invest in a plan, an IP plan. How much does it cost? As a general rule, you can kind of expect that you're looking at about 25 to 50,000 for the entire patenting process over a period of 20 years, but mostly it's front loaded. And that's kind of going to apply regardless. It's on a per country basis. But don't fret. There's ways to mitigate costs. There's multiple ways to do this. First is find the right IP counsel to partner with. Many high quality patent attorneys and firms, I've done it many times in my career, we identify promising startups and evaluate them just like an investor might. And we look at the ability to work with that company and what we think that their long-term prospects are. And often we work on reduced fee schedules or deferred collection schedules. We come up with very creative billing arrangements or discounts. And most attorneys, most firms do this when they look at promising startups. A lot of firms also have relationships with venture capital firms, places that we work together to kind of pool resources and help basically offset maybe those discounts. Find your right financial partners. Just like IP attorneys aren't all equal, nor are venture capital or other types of investors. Many will actually fund IP. They will support you through the IP process because they understand that the IP portfolio is critical for them to really capitalize on their own investment. You want a filing strategy that also spreads out your costs and the timeline to make decisions. That's why I talked a little bit about a common plan or a common program that we use using provisionals and PCTs to spread cost out. Be very active. The more you rely exclusively on your attorney, the more expensive it is. But you know your technology better, right? It's your idea, it's your technology, you know in the marketplace. The more involved you can be and participate, especially in the drafting of the original applications, the more we could save on costs and prevent overruns. I would rather spend that money through strategic counseling and building out a plan and managing and developing a strategy that's a winning strategy than investing it in just application drafting. And so the more you can be involved as an innovator, the better it is to help protect and preserve your resources and to use them effectively. Another resource that I want to point you to is USPTO does have a resource available where there are federal grants and loans that actually are out there that help small and micro entities to find funding to help them protect their intellectual property rights. So the next steps, the future planning, what we always want to think about a long-term vision, right? We're not just talking about today, we're thinking about 1 year out, 3 year out, 5 years out. The more you have that solidified, the better we can work with you to create an intellectual property platform and a portfolio that grows with you and meets what your vision is. I always I tell people to try to set aside a set amount, kind of an investment. And just like you would with banking and savings, when you get money from investors, think about a percentage or a dollar figure that you can allocate towards your IP budget, commit to it and stay with it. It doesn't mean it can't change. You could change that as time goes on, but having a plan and an investment strategy in your IP is really an essential step at the beginning, at the early phases. Be flexible though, adapt your IP strategy as your business either takes its typical ebbs and flows. Find your right partners. I've emphasized this a few times. Having the right people on your side makes the difference. And then ultimately think about your product launch. These are exciting days. Think about your product launch and beyond. But remember, what you have a right in your IP, your patents are exclusionary rights. They're not rights to market or practice. So it's always important as well before you reach product launch to consider your freedom to operate. And that usually involves, again, a careful consideration and collaboration with your IP attorney. And with that, I say thank you very much. It was a pleasure having this opportunity to speak with you. And at this point, I'll turn it back to Audrey.
Thank you so much, Vince. That was hugely informative. I know I learned a huge amount during your talk. We are a little bit over time, but we did have some great questions come through. Do you have a few more minutes to stay
Sure.
on to address a couple of them?
Yeah, absolutely.
Awesome. Yeah, I don't know if we'll get to all of them, but there are a few I definitely wanted to ask you. And the first one has to do with collaboration, which is, of course, what we were chatting about actually before hopping on the webinar, and just, recognizing that collaboration really is critical for moving the alt protein sector forward. But IP concerns can really limit that collaboration. And I think there's some fear that it will slow down the overall growth of the industry. So do you have any suggestions on how to make the industry as a whole more competitive? There's an example given of, I think it's SEMA Tech for the semiconductor industry, or some other kind of way to share IP that would still allow innovators to benefit from their contributions.
Yeah, yeah. A lot of other industries have patent pools, and they have the concept of trying to, you're writing to a standard, and then the members of the party, they share royalty streams. We'll never see that on a life sciences end or an all protein space. But what we do see, and what is an effective way of collaboration, is joint ventures, joint research agreements that protect those and encourage the innovation through a collaborative environment. The important part of those agreements, though, is always spelling out ownership of intellectual property rights, because the parties need to know going in what I own, what you own, and then what assets and how do we come up with an allocation of assets and ownership within that flows from that joint research agreement. But that's really one of the best tools to utilize to protect and encourage collaboration.
Great, thank you for that. And then someone else here is making the observation that larger companies seem to use patents fairly defensively to protect their space, which incentivizes the smaller startups to be in stealth mode to protect their trade secrets until they become patentable. But then there's this feeling, especially among the startup community, that this is really detrimental to getting feedback from potential partners, from getting feedback from collaborators. What would you suggest about what info is better or worse to disclose early on for that young startup? And in general, how can startups or this sector be smarter in thinking about how big companies might be using patents defensively?
Yeah, no, that's a great question, and a great observation by the party posing it. And that's exactly right. Big companies have learned over time, and they have the financial resources to build, very much like I gave that illustration of protecting your marketplace. They have the resources to build that out. And so that is part of the strategy. It's part of the complication as a small startup. How do I get into that space? Because there is always a fear of, if I disclose, what is to prevent a big company from now stepping in and taking my idea and running forward with it? The best thing you could do for yourself is consult with an IP attorney very early on, because the answer is going to depend on the particular company, the particular space, who is the competitor you're really targeting and looking at. We spend a lot of time looking at sort of white space and identifying where we can exploit the growth of IP for a small company that doesn't tip off the big company and end up pushing them in a direction where they get bullied. But in a lot of instances, what we end up doing is we can actually create sort of a blocking patent, or a patent that now a bigger company has to look at and perhaps seek licensing under themselves. So there's an effective way to build that into our strategy of our IP development. The key is getting in with a patent attorney at an early stage and making that upfront investment to try to plan for your company's growth and to be able to navigate that particular problem. But it varies dramatically from company to company. But the best tip I could give is always keep a lid on the idea, and don't disclose it until you're ready to, and until you've made that decision, a trade secret versus patent rights. That's the most critical thing. If you go to, and it is always a problem when you go to you're looking for that investment. If you're not careful about how it's disclosed and what confidentiality attaches, you run the risk of one, preventing yourself from getting patent rights, but two, putting into the public domain what now could be stolen by a bigger company.
Certainly a lot to consider in all of these decisions. Shifting direction slightly, you've talked about hiring a patent attorney, and this question is really about what percentage of all protein companies you work with, or maybe companies in general that you work with, how many have a registered patent attorney as a full-time in-house director of IP? Do you recommend hiring someone in-house, or are most people consulting or using external law firms with expertise in this area?
It depends on the company size. Smaller companies, startups typically will have a relationship with a law firm to help be really their in-house legal team, especially on the IP side, because they don't have the resources to hire a management team. But that will change as the company grows. I would always favor, from when I counsel companies and I see them grow, I would always favor getting an effective business person first and foremost, somebody who's going to help with marketing, public relations, corporate growth and development, interacting with potential financiers. Like, that's your first person. Your second person is probably general counsel, somebody who's not specific to IP, but has a general legal background that can help with contracts, corporate structure, and then only when your company gets to a size where you have a need to manage an IP portfolio internally would you ever consider hiring an IP specific person. So that's down the line. And most companies, whether it's alt protein or any other space as a startup, that typically the IP hiring is down the road, and I end up working directly with the company founders, and then ultimately we get the GC involved and we start working with the general counsel and start building out and maintaining that relationship. But I would not recommend jumping straight to hiring an in-house IP person. Put your CEO, put your business and marketing team, and put your general counsel first.
Great, thank you. And just a follow-up question, kind of a two-parter to we were talking about collaboration before. I think you mentioned that a patent pool would not work. And could you maybe explain a little bit more about why that might not work in the alt protein sector? And then if you could share a broader observation of how patent use has changed over time in the startup biotech space.
Yeah, I mean, patent pools, you're really writing the standards. And the problem with the biotech space is there really is no standard. There's nothing to establish as a framework that everybody's writing to. And there's a lot of variance in the technology. And so we just never would get into the way that they're currently structured. We're not going to get into that kind of statutory arrangement. Now, in terms of patent use and how it's changed, patents are, in the tech sector, are becoming more commoditized. They're more about numbers than they are about real quality. Wouldn't say quality is a negative to the patent attorneys, but rather it's a commentary of what its application is to the business and corporate growth. Because you have just larger numbers, smaller scope, you're looking to make up in volume what you can't acquire otherwise. In the protein space, in the life sciences space, there's a lot fewer patents, but they have substantially more individual value because they're protecting very important things that we do and that are life-changing technologies, whether it be bringing a new food to market, bringing healthier foods to market, whether it's bringing a new drug to market. And so these patents, when we look at how they're used, we see a lot more in terms of policing and maintaining your own patent rights and carving out your niche and using that as a very valuable tool to develop your business plan and your business model. But we don't look at volume per se. We're not looking to fire off 50 different patents to cover what we could cover maybe in 5 or 10. So there's a premium that's placed on very well thought out, very high quality patents that will sustain the growth of the company, but also withstand challenge.
Absolutely. And I keep saying this will be the last question, but there's so many great ones here. This one's a bit more granular. The startup shares a utility patent with an industry partner, 60-40, where the startup holds 60% of the IP. Does this mean that the startup has final say if there's a disagreement relating to that IP? How does that break down?
That's going to be a contractual matter. Usually when you get into the situation where there's whenever there's some kind of agreement of allocation of who holds the cost structure, who holds control is one of those big things. So whenever we enter into some kind of funding agreement where somebody's going to hold, that is going to help to offset cost for patent rights, or it's a joint venture between parties, or it's a shared research agreement, there's lots of different ways we can color it. But that's one of those things that you want to negotiate up front, and is who's going to pick who the outside counsel is, who's going to manage the strategy, what right of reporting exists, what kind of level of input does the party that doesn't hold the final say, what level of input do they have? And those are all things that you want to carefully lay out as part of your original either funding or shared research agreement. You want to make sure that those components are well thought out. There is no default just because you're paying 60% or you're getting 60% of the right that you hold the decision-making authority. That has to be clearly articulated and written out between the parties.
Thank you, Vince. And with that, I'll end us for the day. It is 20 past the hour, but thank you so much for sharing your time, your expertise with us. And a reminder to everyone on the call, we will be sharing a copy of these slides and a copy of the recording so you can revisit all of this amazing content.
Thank you so much.
Thanks, everyone.